Should we start, students? So just giving you a quick review of whatever is being taught in yesterday's lecture, okay? So in this lecture, what we are going to do is we are going to revise the entire Payment of Wages Act 1936, right? Payment of Wages Act 1936 year clearly denotes that this enactment has been passed in 1936, means this is the law that has been made up by whom? British government, and that has been later on adopted by whom? That is Parliament of India, and now it is going to be applicable throughout the nation. And as Article 370 has been removed, now this act is also going to be applicable in Jammu and Kashmir, right? So when it comes to Payment of Wages Act 1936, it is just trying to imbibe the discipline on payment of wages to the worker working in an establishment where this act is being applicable. So when it comes to Payment of Wages Act 1936, it determines that the wage period should not exceed over here in India more than a month. Means the maximum permissible wage period would be a month, right? This act also provides for that on what date the wage should become due and should be paid by the establishment. The establishment is not being provided with their own convenience to determine the due date of wages. The due date of wages is going to be determined by the Payment of Wages Act, so that there would be a kind of stability from the point of view of employee, that when he is going to get his payment, right? This act also determines that wage payment should be made in cash, or it can be made in banking transfer, or it can be made by using the banking instruments. But in certain states, it has been clearly defined and declared that now the wage payment cannot be made in cash. It must be made through banking channel only, through banking transfer only. Like in Delhi, it has been declared that now no wage payment can be made in hard cash or currency. You have to pay it out through banking transfers, that is UPI, IMPS or NEFT, right? If you go through with this enactment, you will get to know that when it comes to duty of payment of the wages, the duty to pay the wages lies on the person who is having the ultimate control of the organization. If you are working in a factory, it would be the manager who is under a statutory obligation to make the payment of wages on time. If there would be any default in or delay in payment of wages under this enactment, or if you will lead to unnecessary deductions or imposition of any unnecessary fines, which is not a subject matter of your own policy document, you would be subject matter of prosecution and penalty provided under this act, right? So over here, the term officer in default is nothing more than a person who is having ultimate control over the affairs of the organization, right? Now further, this act states that when the wage will become due for payment, if an establishment is having number of employee up to 1,000, they have to pay the wages on the 7th of the next month. If they are having number of employees 1,000 or more than 1,000, they have to make the wage payment by the 10th of the next month. When it comes to any kind of transportation business, the wage has to be paid within 7 days from the date of unloading or loading of the material. When it comes to termination of employment due to liquidation or otherwise, the wage need to be paid within the period of 2 working days from the date of termination. While calculating 7 days, 10 days, 7 days, they have just used the plain language that days, right? But while calculating that 2 days, they have mentioned the term working days. That means Saturday, Sunday or any non-working day would not be counted for calculating or computing that 2 days. Wage should only be paid on working day if the due date of payment of wage is the holiday where the organization is not going to work on that day. Wage has to be paid on the preceding day. Now if we'll further proceed, we'll get to know that what kind of things that can be deducted by an establishment when it comes to authorized deductions, right? When it comes to authorized deduction, only 10 items can be deducted, out of which all items are quite very logical, whereas 2 items are subject matter of the internal policy of the organization, when it comes to fines, there should be a stringent and a clear and a written policy in respect of the fines that can be deducted from the salary or wages of the employee. The policy cannot be oral policy. It should be clearly written and communicated to the employee in a conspicuous place of the organization, so that it will be treated as they are having a constructive notice of the fines, right? No fine can be imposed without the approval of the state authorities. Fine can be imposed for omission or an act that has been committed by the employee. No fine can be imposed ex parte. Every employee should be provided with a reasonable opportunity of being heard before imposition of any fine. And there are some further rules related with fine that has been provided in, I guess, section 8, right? Section 7 states that you can also charge for damages caused by the employee or the properties of the organization provided to him for discharge of his duties, right? But when it comes to damages, there should be a proper valuation policy for the damages, and it should not be discriminatory. And the policy for valuation of damages should also be in writing form, right? Other than that, you can deduct income tax, you can deduct insurance premium, you can deduct provident fund, you can deduct absence from duty. Further, some other items can also be deducted, which are quite very logical, that those items that can be deducted as provided under section 7, right? Now, further proceeding with section 8, they clearly states that if you are willing to impose the fine should only be associated with wrong act or wrong omission. Now, maximum permissible fine can be wage period की total wages का 3%, not more than that. If you are willing to recover the fine on installment, you forget it, you cannot get it done. But you can provide for a period of 90 days to the employee from the date of imposition, that he can pay the fine within the period of 90 days, right? Now, if the age of the employee is under 15, forget about the fines, you cannot impose fine. What would be the date of imposition? The date of act or omission will be treated as date of imposition, right? Then they are saying that other than fines, now I think fines we have done with. It says that if you have committed something wrong under this enactment, punishment penalty related provision has been provided in section 15, whereas section 13 states that whatever fine that has been imposed or whatever wage you are paying, you have to maintain a record in a prescribed format, and you have to preserve it for a period of 3 years, right? That is being written in section 13. Then section 15 states that if you are if you are a victim of delay in payment of wages, or if you are a victim of unnecessary deductions and fines, in that situation you would have an option that either you yourself or through your trade union ka representative, or through a police officer or inspector, or through any other person duly authorized by the government to present your case, can put an application with the state authorities, right? If there is a violation of provision of Payment of Wages Act, you cannot approach the central government, you have to approach the implementing authorities, that is called state authorities. If you are approaching them, they may be labor commissioner, they may be regional labor commissioner, they may be judicial magistrate. If you are approaching them, they'll have to resolve the matter within the period of 3 months, right? Which can be extended by the mutual agreement between the parties, right? But if you want to put an application against an employer, you have to put that application within the period of 12 months, right? The limitation period of 12 months will be applicable. If there would be delay of more than 12 months, what you have to do is, you have to justify the reason for delay, right? Along with that, we got to know about the fines. There is no punishment provided under Payment of Wages Act. It is basically a disciplinary enactment, so that there should be a discipline on the part of the establishment, that they would not do anything which is detrimental to the interests of the employees, right? So they are saying that if unnecessary deductions has been made, then maximum up to 10 times of the deduction or 3000, whichever is lower, would be the fine or compensation that need to be paid to the employee from whose wages, right, the amount has been deducted, right? Now, if there would be a delay in payment of wages, maximum permissible fine is, I think, 1500 rupees, right? 1500 to 3000. And if you will make the payment of the wages before the disposal of dispute, the maximum permissible fine would be 2000. Now, if the court has come out with an order that pay him the compensation, you are unnecessarily delaying that compensation amount, rupees 375 will be imposed on the employer. And if employee would file a vexatious claim, then in that case, that is a fraudulent claim or a wrong claim against the employer to defame the employer, one single penalty of 375 will be imposed on him. That's it. We have done with what beta Payment of Wages Act. Everything has been done. We have done with section 1, that is applicability. Section 2 is about definitions. I think I have left the provision of definition. Section 2 clearly states that the rights that has been provided to the employee will be passed on to his legal representative, and the obligation that has been imposed on the employer is going to be passed on to his legal representative, because legal representative is come under the definition of employer and employee. And establishment includes all kinds of establishment involving in mines, quarries, manufacturing units, workshops, transportation companies, public sector undertaking, or any other organization duly notified as an establishment, industrial establishment, by the appropriate government. And section 3 was who is responsible to make the payment of wages. Section 4 is about wage period. Section 5 is about what? That is 7 days, 10 days and all, right? Section 6 is about wage need to be paid through banking channel or cash. 7 is about fines. 8 is about fine related provisions. Then I think 9 was not there. 13 was there. 13 is the maintenance of records, and 15 is fines, right? Right, students? So we have done with what? A quick review of Payment of Wages Act, right? Right, students? Hope online students got everything.